Chapter 9 The Information Technology Amendment Act, 2008. Certificate Examination in Prevention of Cybercrimes and Fraud Management. Subscribe, like, and share. The Information Technology Amendment Act, 2008. The main Indian act that addresses legal challenges specifically as they relate to the Internet is the Information Technology Amendment Act, 2008, or for short, the IT Act. We highlight the sections that have the greatest relevance for the Internet and democracy. This includes sections relating to government takedowns, monitoring and interception of communication and intermediary liability. Section 69A on the blocking rules, allowing the government to block content under certain circumstances. Section 69A of the IT Amendment Act, 2008, allows the central government to block content where it believes that this content threatens the security of the state, the sovereignty, integrity or defense of India, friendly relations with foreign states, public order, or to prevent incitement for the commission of a cognizable offense relating to any of the above. A set of procedures and safeguards to which the government has to adhere when doing so have been laid down in what have become known as the blocking rules. Section 79 and the IT rules, privatizing censorship in India. Section 79 of the Information Technology Amendment Act, 2008 regulates the liability of a wide range of intermediaries in India. The section came in the limelight mostly because of the infamous Intermediary Guidelines Rules, or IT rules, which were made under it. The IT rules constitute an important and worrying move towards the privatization of censorship in India. Sections 67 and 67A, no nudity, please. The large amounts of obscene material that circulate on the Internet have long attracted comment in India. Not surprisingly, then, in the same way as obscenity is prohibited offline in the country, so it is online as well. The most important tools to curtail it are Sections 67 and 67A of the IT Act, prohibiting obscene and sexually explicit material respectively. Section 66A, do not send offensive messages. Section 66A of the Information Technology Amendment Act, 2008 prohibits the sending of offensive messages through a communication device, i.e. through an online medium. The types of information this covers are offensive messages of a menacing character, or a message that the sender knows to be false but is sent for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred, or ill will. If you are booked under Section 66A, you could face up to 3 years of imprisonment along with a fine. Freedom of expression. To balance freedom of expression with other human rights is, at times, a difficult and delicate task. From hate speech to intermediary liability, we tease out and shed greater light on the various challenges that make this task particularly complicated, proposing ways forward that can further strengthen and promote the right to freedom of expression, in India and beyond, as well. Cybersecurity, surveillance and human rights. With the advent of new technology, new security threats have emerged for people, businesses and states. Oftentimes, responses to such threats, including states' exercise of their unprecedented power to surveil their populations, have been criticized for their negative impact on human rights. Can security and human rights no longer be reconciled in the Internet age? The Information Technology Amendment Act, 2008, an act to amend the IT Act 2000, received the assent of the President on 5 February 2009. Several legal and security experts are in the process of analyzing the contents and possible impacts of the amendments. The objective of this note is to try and study the possible implications and impacts on Indian companies. This note is not intended to be a comprehensive analysis of the amendments, but only certain key points which could impact Indian companies' data protection. The IT Act 2000 did not have any specific reference to data protection, the clause being a provision to treat data vandalism as an offense. The government introduced a separate bill called Personal Data Protection Act 2006, which is pending in the Parliament and is likely to lapse. The ET 2008 has introduced 2 sections which address data protection aspects to an extent, which gives rise to certain key considerations for the sector. The sections under consideration are Section 43A, Compensation for Failure to Protect Data, Section 72A, punishment for disclosure of information in breach of lawful contract. Section 43A states where a body corporate, possessing, dealing or handling any sensitive personal data or information in a computer resource which it owns, controls or operates, is negligent in implementing and maintaining reasonable security practices and procedures and thereby causes wrongful loss or wrongful gain to any person, such body corporate shall be liable to pay damages by way of compensation to the person so affected. By way of explanation, body corporate means Indian companies' reasonable security practices mean a mutual contract between the customer and service provider or as per the specified law. In absence of both then as specified by the central government, hence it would be important for Indian companies to seriously look at SLAs and agreements which have been signed with clients to understand the data protection implications. The same goes for understanding the applicable laws. A major modification is that this clause doesn't mention the compensation limit of 1 rupee crore which was there as part of Section 43 of the ETA 2000. This implies that there is no upper limit for damages that can be claimed. This essentially is unlimited liability for Indian companies, which could cause serious business implications. Section 72A. Under this section, disclosure without consent exposes a person including an intermediary to 3 years imprisonment or fine up to Rs. 5 lakhs or both. This section uses the term personal information and not sensitive personal information as in Section 43A. Hence it could apply to any information which is obtained in order to deliver services, hence in some ways broadens the definition of information. 2. Information preservation. Across the amendments there are several references to service providers or intermediaries, which in some form would apply to all Indian companies. For example, Section 67C, Preservation and Retention of Information by Intermediaries. Intermediary shall preserve and retain such information as may be specified for such duration and in such manner and format as the central government may prescribe. Any intermediary who intentionally or knowingly contravenes the provisions shall be punished with an imprisonment for a term which may extend to 3 years and shall also be liable to fine. The notifications on time for preservation etc. are not yet released. However, since this is a cognizable offence, any police inspector can start investigations against the CEO of a company. Apart from the 2 aspects discussed in this note, there are other areas which could also be considerations for example, Sec 69, power to issue directions for interception or monitoring or decryption of any information through any computer resource. Sec 69b, power to authorize to monitor and collect traffic data or information through any computer resource for cybersecurity. etc. In summary, IT risk management and response needs to be looked at by all companies for various reasons including customer assurance, compliance, customer regulations, protection of information assets etc. The ETA 2008 amendments provide us with few additional factors for considerations which could have significant impact on business. Information technology regulations and laws would only get more stringent and defined, hence it's imperative for organizations to be aware and prepared. The Information Systems Audit Group assesses the university's critical systems, technology architecture and processes to assure information assets are protected, reliable, available and compliant with university policies and procedures, as well as applicable laws and regulations. We emphasize the importance of mitigating security risks during our audit coverage of the university's application, operating and networking systems. Through our integrated and IT governance audits, we evaluate information technology's impact on the university's processes and its abilities to achieve its goals and objectives. Our evaluations are objective and professional, utilizing COBIT, Control Objectives for Information and Related Technology, framework, an international standard for good IT control practices. ISHA provides the following audit services: IT governance. IT governance audits include reviews of the organization's fiduciary responsibility in satisfying the quality of IT delivery services while aligning with the business objectives and establishing an adequate system of internal controls. Information systems audits focus on security controls of physical and logical security of the server, including change control, administration of server accounts, system logging and monitoring, incident handling, system backup and disaster recovery. Integrated audits. Integrated audits include reviews of the business operations and their dependency of automated systems to support the business process. We consider information technology and financial and operational processes as mutually dependent for establishing an effective and efficient control environment. From the technology perspective, the audit focuses on application controls, administration of user access, application change control and backup and recovery to assure reliability, integrity and availability of the data. Control self-assessments. Control self-assessments are designed for department that manages and operates a technology environment. These self-assessment tools can be used to identify potential areas of control weakness in the management of the technology environment. Compliance. Compliance audits include university policies and procedures, payment card industry, PCI, the Health Insurance Portability and Accountability Act, HIPAA, Family Education Rights and Privacy Act, FERPA, and any other applicable laws and regulations.